All right. Well, listen, happy Friday, everyone. You made it through a week. It's TGIF. It's on the East Coast. It's a little bit after 7:30 right now, but we're still going strong here at the workerscompensation.com news desk because we love this stuff. What else can we say about it? We've had some interesting cases come out this week. We've got some that we're going to be reporting on tomorrow. Some interesting news, interesting stories. We'll get to that. But I did want to talk about an interesting case that showed up this week via one of Chris Parker's wonderful "What Do You Think" features. He does a great job covering those for us, and we've had a couple good ones rolling along. And there's one that I thought was pretty interesting that came out. It was actually an FMLA case, but we have expanded our offerings. We have our HR homeroom sort of umbrella that looks at more than just workers' compensation cases, because we know some of you are interested in employment issues or sort of like labor management issues, those types of things. And FMLA falls under that category. And there's sometimes when there's going to be overlap between a workers' compensation injury and potential FMLA leave. So that's within our wheelhouse, and it's something that's interesting to us. So let's go ahead and share the screen here. We're going to get started to let you know what's going on in the world of workerscompensation.com this week. We're going to get going, and this is some of our news that's coming out tomorrow. We'll get to that in a second as a part of our wrap up. We'll give you a sneak preview of what you can see. It's already up there, so you can go to the site, but it'll be in tomorrow's LinkedIn newsletter. So here's some other recent information that's going. We've had a good set of articles, I think, over the past few weeks. Our writers do a fantastic job of covering a variety of topics so that whatever segment of this industry or this space that you're interested in, that you work in, our aim is to have something useful there for you. So there you go. Now let's go ahead and keep rolling here. This is a workers' compensation retaliation claim that Chris wrote on. And the case was really boiled down to civil procedure, but it's interesting, particularly for those who practice law in this area. That's one that you might want to check out. But before we do, let's go ahead and take a look at this case. I guess it's farther back. There we go. Flight attendant. Kind of a classic case here in a lot of ways, as to the question of why did I lose my job? So he goes out on FMLA. First of all, he has some bad behavior there. You can read about it. He was having a romantic relationship with a female coworker about 20 years his junior, and she wanted to break it off. Not surprising once you see some of the text messages that he sent her. And one of the texts, he left some threatening text messages, threatening voicemails. Word to the wise, those are always going to come back and be evidence. So there you go. But, emotions run hot in these types of things. And he threatens her some pretty threatening, bullying, cyber harassment types of threats here. And you can read about that. And so then anyway, he was suffering from alcohol use disorder, which is a serious medical condition, and he requested FMLA leave for it. And FMLA, that would be an approved reason for FMLA leave, and he got it. He got his leave, went to rehab, thankfully. But while he was in rehab and while he was on FMLA leave, the company, the airline, decided to fire him for this harassment that occurred. Which, kind of makes sense. He sent these harassing text messages, left harassing voicemails of his coworker. They exercised their, sort of powers under the harassment and discrimination policies and terminated him. So he says, well, hey, listen, I had a right under the FMLA to be reinstated. That's what the FMLA says. I have a right to take medical leave for a qualifying serious medical condition and have my job restored to me at the end of it. So that's the charge he brings. So the question here is, did United interfere? There's a type of FMLA claim. That's an FMLA interference claim, which is what he exercised here, because what he's saying is that the employer interfered with his rights under the FMLA. And that's the question that Chris poses here. He says, well, did United interfere with the attendant's right to reinstatement under the FMLA? And then the choices, of course, are no or yes, and the reasons why. So, no, he was not. He was going to be fired anyway, regardless of whether he took FMLA leave. If he had continued on with the company, and you can see, by the way, just to pause that thought for a second, you can see how this almost, parallels sort of a retaliation case. But what he's saying is, and this, is probably the correct. Well, I'm not saying probably. The attorney knew what he was doing, because what he's saying is that the retaliation claim is a little bit difficult because he was given his FMLA leave. It wasn't like they took it out on him, and he didn't get a chance to come back for there to be sort of a retaliating sort of action. So the interference claim is what, I can see the attorney probably thought that's what would hold the most water here, because he's out on FMLA leave. They granted it to him, right? And so what he's saying is, well, you gave me so you sort of recognized it, but you didn't give me the chance to be reinstated, to be restored to my position. That's how the argument would go. But the court says, and this got up all the way to the Seventh Circuit, by the way. Now, it's an unpublished case, so it's not like binding precedent. But it shows you that the Seventh Circuit is looking at this and saying, hey, yeah, of course he wasn't reinstated to his position, but he was going to lose his position anyway. So, whether if this had never come up with his leave, his medical leave, or his reason for taking FMLA, if that had never happened, he was going to lose the job anyway. So there's nothing to restore him to. He doesn't have that job anymore. Makes sense. And it's a good reminder of how it's important to address bad behavior that employees exhibit toward other employees on the job. So there you go. There's the case there. You can read about it from our Chris Parker right there on the daily headlines from a couple of days ago in a What Do You Think feature. So what can you expect for tomorrow? Well, let's go back to the news page here. And you can already read it. Like I said, there it is. So Claire Musselman, Dr. Claire Musselman, soldiers on with her compassion fatigue series. Something that I sound like a broken record sometimes, that, every time she writes something, I learn more than I expected, and I enjoy it more than I expected. And this has really been the case with the compassion fatigue series. Like I said today, if you follow me on LinkedIn, I said, normally you see that kind of thing and you think, oh, this is a soft skills thing or something like that. But then you read it, and what her genius is that she shows the business case for why understanding compassion fatigue is important, and then what to do about it. Now that you know the business side of things, there's costs to it. There's retention costs, errors and omissions costs, all these kind of things. And you can do something about it. And that's what she breaks down in this article. Liz Carey always brings us interesting news. It's news that we would rather not cover, but it's out there. Workers doing their job face risks from all angles. And this is no different. The sort of foundation of this story is a customer was waiting for his laundry order to be done, and became upset about how long it was taking, and ended up stabbing a worker. His bill was only going to be $15 and change, but no matter, he was upset about it. Kind of thing that workers who have direct interaction with customers face quite a bit, and Liz has covered it for us throughout the years here. And then the Nevada Supreme Court took on a couple of precedent cases, overruled them, at least to the extent that it applied to the legal issue in this case, which had to do with subrogation and whether a workers' compensation insurer could collect on a lien when the injured worker goes and uh, reaches a third party settlement. And that's what happened in this case. The worker was injured on the job. Insurer paid out workers' compensation benefits. Then the worker turned around and settled with the company there on his injuries. Got a $400,000 settlement. So the insurer naturally is looking to recoup some of the $173,000 it shelled out in workers' compensation benefits. So you can read how that went down and what the Nevada top court had to say. All right. So listen, we really, really, really appreciate you spending a little bit of time with us. And we hope you have a fantastic weekend, no matter what's in store. And we would be remiss if we didn't say that our hearts and our minds and our thoughts and our prayers and all that are with the people who were affected by Hurricane Helene. Many of us that work for the company were subject to some of the effects of Helene. Fortunately, not the worst of it. But for those of you who may have been, trust us when we say that we are thinking about you. And if there's anything that we can do to help, don't hesitate to let us know. Other than that, enjoy your weekend. And thank you so much for being part of this session. Have a great one, guys.